Hi, Christian. Well, thank you very much. Some great questions. Now, let me see if I can share my PowerPoint. I haven't done this before, so hopefully this will work. Where is my PowerPoint?
There you are.
Okay. Let me put it in slideshow mode. Okay, so let me tell you a little bit about myself. My name is Paul Wolf. I'm an attorney in the Buffalo area. I'm in private practice right now, but in the past, I worked a couple of different government positions. I served for a period of time as Chief of Staff to the Buffalo Common Council, General Counsel to the Buffalo Housing Authority, and Counsel to the Erie County Department of Social Services. So in those positions, I dealt with, excuse me, open meeting law issues and freedom of information law issues. And so I guess to say I've been on the other side of the aisle on these issues. But now I'm involved with the New York Coalition for Open Government, where I serve as president. Our organization has been in existence for 3 years now. We're a New York nonprofit. We haven't become a federal 501c3 yet, but that's something we're working on. Our efforts are nonpartisan. Quite honestly, I think Republicans and Democrats are equally bad when it comes to open government issues. It typically depends on who's in control of a particular local government as to which way it goes. But our main focus is advocating for timely access to information through open meetings and freedom of information and meaningful citizen participation. So that's what we focus on. You can learn more about us at our website at nyopenGov.org. We have a Facebook page where we post a lot of information that you can follow. We've done a series of reports. We started out as the Buffalo Niagara Coalition for Open Government, focused on just the counties of Erie and Niagara. And we've recently changed our name and are now expanding our efforts to a statewide focus. We've done a series of reports regarding compliance with the open meetings law and compliance with the freedom of information law. So that's what we're about. Today, I want to express our viewpoints about some ways you can go above and beyond the open meetings law, some interesting things that the law doesn't mandate, which a lot of people, I think, are surprised to learn. And I should say, although that Kristen O'Neill is participating in this forum, it doesn't mean that she necessarily agrees with our opinions on all of these issues. She gave you an overview of what the law requires, and I'm going to give you an overview of how the law should be changed, perhaps to require more, or ways that you as a citizen, an elected official, can advocate to go above and beyond the law. So it's interesting to me that the open meetings law doesn't say anything about agendas. It doesn't mention meeting agendas at all in the law. You're not required to have a meeting agenda, although, any productive meeting certainly has one, and every government body that I've seen has one. But interesting that the law doesn't mandate that you have one. And open meetings law does not mandate that you have to post documents online. It says if you have a website that's updated regularly and to the extent practicable. I love that word as an attorney, which basically means to me, as best you can, you should post meeting documents online. I don't interpret that as a mandate. Perhaps some would, but I think the law should mandate that in today's day and age, you have to post meeting documents and agendas within a certain time period before a meeting. Some local governments will literally just post a one-page agenda of meeting topics. And while that's nice, I don't think it's very informative or very helpful. Some will post just resolutions that they're voting on. We advocate for posting everything. It's very easy to, whatever documents a city council member, a town board member has in front of them, the public should see online. Just scan and copy the entire board packet and post it online. Now, many local governments do that. In the town of Amherst, where I live, they will sometimes have 600, 700 pages posted online. Every single piece of paper that's in front of the board member that they're discussing and voting on is right there for the public to see. But not everyone does that. And I think in today's day and age, with the technology, the law should mandate that you have to. It's shocking to me and a lot of people that the open meeting law does not mandate that the public be given the opportunity to speak. It shouldn't be as a courtesy or, we're going to be nice and we allow you to. We believe the law should mandate that the public has an opportunity to speak at every public meeting. I mean, typically people are given only 3 minutes to speak. I don't think it's unduly burdensome. It's interesting that, for example, the Buffalo Common Council, you cannot speak as a citizen to their full council meeting. They don't allow it, and they don't have to. The same thing for the Erie County Legislature. You cannot speak to the full legislature meeting. They don't allow it. You can ask to speak at a committee meeting, which I, as a citizen, have done, and I've been denied. No, we're not going to let you speak. So in the Buffalo Common Council, they do let the public speak at committee meetings, but not at the full council meeting. So you never get the opportunity to address all 9 members when they're voting on something. And we believe the law should mandate that. In this emergency situation, it's being mandated, live streaming of meetings or video recording of meetings, but in general, the open meetings law does not mandate that. And hopefully this will become a new practice that more and more local governments utilize. I think it's a great way to inform the public. It's interesting, a couple months ago, the state legislature mandated that industrial development agencies must video record their meetings and post them online. So they mandated IDAs to do it, but not other governmental bodies to do it. And hopefully, after this emergency situation, that's something that can be mandated. There is no mandate that meeting minutes be posted online. The law requires that meeting minutes be made available if someone requests them, but it's not mandated that they be posted online. We think that should be mandated. And those that do it oftentimes are weeks or months behind. Some are on top of it, but a lot of local governments are not. So as I said, the law sets the minimum low bar. It's the minimum requirements that you must do, but you can strive to do more, and we hope that local elected officials will strive to do more to bring more transparency to government. So leaders committed to open government should adopt these best practices. These are things that you're not required to do by law, but you as a local official can strive to do. Post meeting agendas with all documents online several days before the meeting. Provide the public the opportunity to be heard early in the meeting before votes are taken on items. There are some local governments that they will do all their business, cast all their votes, and then the last thing they do is to hear from the public. And we don't think that's a good practice. I mean, you should want to hear from the public before you vote on items to get their thoughts and opinions on matters. Some local governments will also distinguish that if you're speaking on an agenda item, we'll let you speak early in the meeting. But if you're speaking on something that's not on the agenda, you have some particular issue or concern, you have to wait to the end of the meeting. And I don't know why we divide the two. I've had to do this where I have to wait 2 hours at the end of the meeting to speak for 3 minutes. I mean, if someone takes the time to attend a meeting, why not hear from them earlier in the meeting? Why make them it's almost a punishment to make you sit till the end of the meeting. The Niagara County Legislature has an awful practice that if you want to speak on an agenda item, you have to wait to the end of the meeting, so literally 2 hours, and they literally adjourn the meeting before they hear your comments. So people are walking out, it's very disruptive as you speak, and the fact that you spoke is not documented in the meeting minutes because the meeting was over. We heard your comments after the meeting was over. It's not documented in the minutes. It's as if it never happened. So terrible practice. While not legally required, we hope that people will advocate for live streaming of meetings, video recording them, posting them online. We encourage people to post meeting minutes online within 2 weeks after a meeting. Again, they have to be made available within 2 weeks, but there's no requirement that they be posted. As Christian said, you can post draft meeting minutes. You don't need to have them approved. So we think that's a good practice for people to follow. This topic came up. I think it's the biggest loophole. It's actually technically not a loophole in the open meeting law because it's an exemption to the open meetings law, and that is private political party caucus meetings. I think this is a terrible practice. As Christian said, what it allows is members of the same political party can hold a private meeting, no notice, no press, no members of the public, and legally they can discuss not only party business, but public business. I think it's a terrible practice. A lot of local governments do it. It's interesting that in the 80s, there were some court decisions that came down that said, you should not be allowed to discuss public business in a private political caucus. And the legislature actually went back and amended the law to add in that public business can be discussed in a private political caucus. There are some caucus meetings that they bring in department heads. They basically have a whole private meeting questioning staff, and they can do it long as it's only all elected Republicans or all elected Democrats, conservatives, whatever the political affiliation may be. But I think it's really subject to abuse, and it's something that should be avoided. I mean, on that topic, Ithaca City Council passed a local law in 1985, which I think is very interesting. They passed a local law that says, all right, if we're going to do political caucus meetings, we're not going to allow public business to be discussed during those caucus meetings. So they actually passed a local law that went above and beyond what the state law requires. And I think this is a great practice that others should consider adopting. So that's all I'll say on that topic. Executive sessions came up. They should be rare and held for the right reasons. There are some local governments that we took a look at that literally every single meeting they have an executive session. It's just something that should be a rare occurrence. Just because you can discuss something in private doesn't mean that you have to. So there's a lot of mistakes made when holding executive sessions. As Christian said, you have to be very specific. And we see a lot of executive sessions where people say, we're going to go into executive session to discuss a personnel matter. That's not enough. You have to specify. Are you going in to talk about disciplining someone, firing someone, hiring someone? Again, you don't have to mention names, but give some specificity as to what it is that you're going to be talking about. Just saying to discuss a personnel matter is not enough. Same thing, we see a lot of executive session to discuss litigation. Not sufficient. You need to specify, state the name of the case that you are discussing, the legal issue that you're discussing, and really the whole purpose of that litigation for executive session is to be discussing legal strategy. It's not just to get an update of what the status is regarding a lawsuit. You can do an update in a public session where the attorneys tell you where we're at in the court proceedings. It's really meant to discuss legal strategy, which quite honestly, you as an elected official probably shouldn't be involved with. Leave that to the attorneys to handle. But litigation is a common mistake made when doing an executive session. Contract negotiations. You can't say simply, we're going to executive session to discuss contract negotiations. You need to specify if it's a collective bargaining agreement, what union, what agreement. If it's some other type of contract, specify. Not just vague contract negotiations. You can change how executive sessions occur. Legally, you only need a majority vote to hold an executive session, but you can require more than that. I thought it was interesting that the New York City Council actually has a requirement that they have to have a 3/4 vote to have an executive session. Now, most votes for an executive session that I see are unanimous, but it's not a bad practice, again, if we want to be serious about limiting these. Why not make it a little harder for an executive session to occur? One of the biggest issues we have with the open meeting law is that it lacks enforcement power. And the New York State Committee on Open Government does not have any enforcement power. They're a great body. They have advisory authority and opinions, but to enforce a violation of the open meetings law in New York, you as a citizen have to hire an attorney, which is not cheap, costs a lot of money, or the only other vehicle we have is the news media. Just sometimes we have to embarrass folks, or a critical news article seems to prompt change, but that's something that really should be changed in New York State, and we're going to take a look at some other states where it's done differently. So Massachusetts has enforcement powers. Citizens in Massachusetts can file a complaint with the state attorney general. They have a great website, a form that they provide for people to fill out. The attorney general has the authority to investigate, the authority to fine governmental bodies for violating the law. Hey, Ed, for some reason you're on the phone. If you could, I can hear you. I don't know why. If the governmental body disagrees with the attorney general decision, the governmental body can file a lawsuit. So they kind of flip it in Massachusetts. Don't leave it up to citizens to litigate, but the attorney general will take action, and if the governmental body disagrees, they can litigate it. So I think that's a good model for New York to take a look at. Vermont has some good language in their open meetings law. They require that meeting agendas must be posted online 48 hours before a meeting. Public, I would prefer 72 hours, but okay. The public must be given an opportunity to be heard. So by law in Vermont, the public has to be heard at their meetings. Vermont requires that meeting minutes must be posted online within 5 days of the meeting. There was a lot of controversy in the state when that was adopted, but they've been doing it. So these are just some examples of nearby states that have, I think, some stronger requirements in their law. So just kind of summarize 8 steps that you can take as an elected official or an advocate, or advocate for as a citizen. Allow the public to speak at your meetings before any voting occurs, early in the meeting, whether it's regarding agenda item or a non-agenda item. Live stream your meetings, post videos online after your meeting. Some places will just live stream them, but then don't keep them. It's a real benefit for the public to be able to see them if they miss the meeting. Push for your local government to post meeting agendas with documents online several days before a meeting occurs. The Erie County Water Authority up here in Buffalo area, which has been long a poster child for bad government, they now post their meeting agendas and documents online 5 days before their meeting. As far as I know, they do it earlier than any other governmental body. Question the need for executive sessions. Monitor if they are done correctly. Require 3/4 votes for such sessions. Few more. You could introduce a resolution as a local official or advocate as a citizen for your local government to amend the open meetings law to include some of these requirements. We're going to be doing a push. We're working on laying the groundwork to advocate for amending New York's open meetings law. You can create an open government advisory board consisting of concerned citizens. I did that in Amherst, New York. I drafted a local law and submitted it to my town board saying we should do this. And fortunately, they have done it. We have, committees of all kinds of topics and issues, but most governments don't have an open government advisory board at the local level. I think it's a great idea and something that others can adopt. Pass a local law, rule of order, or resolution that prevents the holding of private political caucus meetings. You can eliminate them. You don't have to have them. Or at the very least, at least eliminate the discussion of public business in a private caucus meeting, which is what Ithaca, New York has done. Post meeting minutes online within 2 weeks as a draft. The sooner you get them up, the better. And lastly, I just want to say that we're here to help. So that's our website, Facebook page, my contact information. We are recording this meeting, so I will post it to our website afterwards for people to view. So I'm going to stop sharing and I'll take a look at chat and see what questions people may have. I don't know if there's any for me or if those look like they might have all been for Christian. I don't know if you see anything different, Christian. I can't hear you.
Sorry, talking is muted. The last thing I have is a note to everyone answering a question about public hearings.
Okay. So looks like there may not be any additional questions. So I think this was great to do. This is the first time I've done a Zoom meeting with this many people and as a host. So I think we made it through without too many technical glitches. I would say I do want to thank two people. I want to thank Joe Kissel, who's the secretary of our group. It was his idea to do this. I didn't want to do it. I said we should wait until September and maybe we're through all this craziness and we'll do a live meeting. And Joe said, look, everybody's stuck at home. Now's the perfect time to do it. So he was right. And I also want to thank our treasurer, Janet Vito. She's the one who tracked all of the RSVP responses, and she's very organized and detailed, and she kept us all on track in doing this. So Christian, I don't know if you have anything else you want to say in conclusion.
No, just thank you for inviting me to do this. I think it's a great way to get in touch with a lot of people. I had never used Zoom before a month and a half ago, and now I just, it's nice to get more familiar with the technology and familiar with ways to make government more accessible. So I appreciate the opportunity to participate.
I did have
Paul,
a question.
can you hear me?
Oh,
Paul, this is Nancy Correa. Can you hear me?
yes, I can.
Okay, my question is for either of you, and it has to deal with board meetings, where I have seen board members sitting on the dais texting each other. We don't know what the text consists of, but I have been able to understand in speaking with board members prior to the meeting how they intended to vote. And after the texting, that has changed. Is there any way to curtail that? can we include it in regulations that there be no texting during a board meeting between board members or among board members? Because I've seen 3 of them texting each other.
I'm not sure, I don't know about regulation, but first of all, it's bad manners to be engaging in text conversations. I also, depending on whether it's a group text or one-on-one text, it may not be consistent with the open meetings law. So, for example, if you have a 5-member board and all 5 of them are on a group chat and texting each other, essentially they have found a way to have a behind closed doors meeting. And in my opinion, a court may look into that and find that those actions were inconsistent with the requirements of the open meetings law. I think one-on-one texts are going to be a different story because the communications are not between or among a quorum of the board. I still think it's bad manners. I think the way to address it is to encourage your local boards to adopt policies prohibiting it.
Well, I've seen both, one-on-one, and I've seen group where 3 members are involved. And I doubt very much that they would adopt that. I was hoping that maybe there could be something written into the regulations that the texting would have to be open enough to the public attending the meeting or being videotaped to know what was going on.
I don't know how you would videotape texting. I mean, they do become records subject to the Freedom of Information law. If they relate to public business, the likelihood is they can be withheld because they're interagency material under the Freedom of Information law.
Okay, so
there are no open meetings law regulations. So any change would have to be through state legislation.
Okay. That's what I was afraid of, because I don't think that the board I have in mind, which is town of Lewiston, where I formerly lived, was consistent in doing that. So they were having their own private meetings while the supposedly open meeting to the public was going on. The private meeting was through texting. But thank you for your answer. I was afraid it would be a legislative matter.
I have a question.
We've been doing the questions through chat, but Nancy was actually on the phone instead of on the computer. But now I see people are raising their hands, and I don't know if we want to get into this or not. But you want to try, Christian, or no?
Yeah, maybe a couple, but we probably are pushing up against the limit of what people. We're almost at an hour and a half, so maybe a couple more minutes.
Ed. I heard somebody say something. All right, let me go to Dan.
Daniel Sack.
All
yes,
right.
Asked some questions about public hearings, which of course I know they're not part of the open meetings law. I don't know why they aren't, but who in Albany, maybe someone else, another agency, who can I ask these questions to about public hearings? Because the way they're conducted in Buffalo City Hall is often very unfair to the public.
Well, as you can see, I responded to you. There is no single oversight entity because there's a myriad of different statutes that govern those public hearings. So it depends on the type of hearing. There's no single oversight entity.
That's sad.
Well, no, they still need to comply with statute, and essentially oversight or enforcement of any of these statutes is ultimately going to be through the courts. We don't have enforcement authority over meetings either. We can provide advice, but
Paul?
Yeah, Ed.
Okay, I have a question, and Paul, I did submit something in chat, so I'm following up with the question.
Sure.
It's directed primarily, I guess, to Kristen. Concerning all the government or the governor's executive orders regarding suspending certain aspects of the open meetings law, is there any kind of protocol or on this? I mean, he did a lot of executive orders suspending a lot of things. Is there a sunset provision that forces him, or that he has to at least periodically review these things and explain why he's holding some back or why he might be reversing some, or else can he just literally let these executive orders stand theoretically in perpetuity until he chooses to, if ever, chooses to reverse himself?
Well, the ability to issue an executive order is dependent on disaster emergencies or, emergencies.
Right.
And so his ability to suspend provisions of statute is based on our current situation. And each executive order does have a sunset date. And
Okay, well, that's
unless
why
extended,
that's why I'm asking the question, because I did not know that.
Well, what is the question? Okay, so your question just is, do they sunset?
There's a sunset provision where he has to review all of these executive orders and determine
it's in
whether
the actual
he wants.
executive order. If you look at each executive order includes a date at which it expires. And
Okay.
unless it's renewed by a subsequent executive order, it will expire on that date.
Okay, as a private citizen who isn't familiar with all the intricacies of the New York State government, that's something I didn't know, and that's why I'm asking the question. So I'm happy to hear that provision is in there. I just did not know that. Thank you.
All right, Sonia?
Yes, glad we're having this. I attended a zoning board of appeals meeting, and I afterwards requested that I be provided a copy of it. The clerk said yes, would take a couple of days. I went in there, it was Monday, the meeting. I went in Friday expecting I would be able to get that audio, and I was told I have to fill out a FOIL. I did fill out a FOIL, and 5 days later I got a response. It's being reviewed in the attorney's office, and it will be 30 days when I get a response on my request. My question is audio under the Freedom of Information law? Can I receive that?
Yeah, no, certainly it's a public record. A recording of an open meeting is clearly a public record subject to the Open Meetings Law. There should be no reason for delay in responding to a request of that nature. Of course, as I'm sure you understand as well, is that all municipalities are working with reduced staff, but a request of that nature shouldn't require an attorney review. It's clearly public. So I'm not really sure why there's such a significant delay, unless for some reason they're running into technical difficulties with preparing the copy. But if that's the reason, that's what they should tell you, because you'd probably be more understanding of that than someone telling you that it needs to be reviewed by an attorney, which doesn't make a lot of sense.
He said 30 days. As I read the law, it's 20 days. But, I'm understanding of the emergency we're under right now. Yeah. But I would think I'd get at least a response. The point is, very specifically, I thought I had a right to it. Is there any reason that you know of?
I can't think of any reason why you would be denied access to a copy of a public meeting.
That's what I thought.
And the 30 days could just be the law says 20 business days sometimes, and 20 business days tends to equate to approximately 30 calendar days. But still, I'm not really even sure generally why it would even take that long to provide you access with a record that is clearly public and should be easily accessible.
Kristen, you in your presentation, you mentioned executive law. Is there anything with this emergency that the governor has written in an executive law that that would be under it, that I would not be receiving an excuse, a reason not to receive it under this emergency?
There's been no executive orders relating to FOIL, is that what you're asking?
Yes, on specifically getting, not being denied.
Right, there's been no suspension of any aspect of the Freedom of Information Law by executive order.
Thank you.
All right, well, I think we're going to wrap it up now because we've been going for an hour and a half and I see some people are leaving. So I want to thank everyone for participating. Thank you, Christian. And we're going to end it and put the recording up when we can on our website and go from there. All right.
Great. Thank you, Paul.
Thanks.